A question I'm getting quite frequently now and want to explain to everybody is, what should you do if you're caught for your first time shoplifting, and this is in Santa Clara County, and what to expect? So there's a couple different ways that your case can go, at least to start. And the first way is your case never actually gets charged in court. So what happens is you get the citation for shoplifting. You're usually not going to go to jail for shoplifting because the amount usually is the petty theft amount under $950, okay? And that's who, we're going to be addressing right now, is these misdemeanor shoplift offenders when there's an amount of loss or taking at $950 or less, okay? And in this type of situation, like I said, there's a couple ways that, the case could go. Number one, your case doesn't actually get charged by the prosecutor and sent to court, okay? And you get offered instead essentially a pre-filing diversion program, and with that program, the district attorney makes a decision you're eligible for the program. Pretrial services for Santa Clara County will then reach out to you, send you a letter and say, hey, you're eligible, but now what you have to do is you've got to do a certain amount of community service hours, you've got to do a theft awareness course, and you have to complete it within a certain time period, and also not pick up any new law violations. And if you do all that, then hey, great, your case is never going to be filed. You're never going to have to deal with the court. In terms of your record, yeah, you will still have a arrest record, even though maybe you were never arrested, you were fingerprinted only. Maybe you weren't even fingerprinted, and then we'd have to discuss if you'd have, an arrest record. But generally, you're going to have an arrest record, okay? An arrest record's not necessarily something that's easily searchable by the public. The arrest record is a public record, so it's not, confidential by law. Generally, though, when you're looking for employment or you're dealing with other people, they're not going to know about your arrest record. There's not going to be easy place for them to search or look for your arrest record. Generally, what people can see are employers or background search companies. They can see if your case has been filed, and they'll check court records for that. But the arrest records, that has to be obtained through the police department, or certain media companies do make requests for these arrest records from the police departments, and they'll put it out there on the internet. So you got to be careful. There's ways for your arrest records to be public, so just to be aware. You can, in the future, do what's called a petition to seal your arrest record. You're generally going to have to wait a 1-year time period for the statute of limitations to pass from the date of the theft in order to seal your arrest record, but that is going to be possible. You'll be able to do that in the future. That assumes that you successfully complete this pre-filing diversion program that may be offered to you by the district attorney's office. So that's kind of option number one. That's, what's left on your record. There's still an arrest, but you can get it sealed after the statute of limitations has passed. Okay. Number two, before we leave that, there's technically another way to seal your arrest record. It's called a petition for factual innocence, but I'm assuming that, you weren't actually innocent in that scenario. We'll discuss that later. That would seal the arrest record faster than waiting 1 year, and it actually give you a more complete type of sealing. So just FYI about that, okay? Now, the second option is if you don't get the pre-filing diversion, then the prosecutor's going to file your case in court. And you may be wondering, well, how am I going to find out if I'm getting pre-filing diversion or I'm not getting pre-filing diversion? It's all up to the prosecutor's discretion, so I can't tell you that either. I can generally tell you the lower the amount, the fact that you are a first-time offender, and possibly the fact that you're, younger as opposed to older. I think that may influence you getting pre-filing diversion. The age is not going to... You could be young, you could be old. As long as you're a first-time offender, that's generally what it is. I would say there might be some preference, though, for a younger person, like maybe 18, 19, so that they're not, marred by this, record, moving forward into their early adult life. I think there may be a little bit greater consideration for that. That's my personal feeling, but that's not, I don't have proof of that. I can't prove that to you, okay? So for, the decision of whether your case is going to actually go to court or not, that's up to the prosecutor. And there's some things that we can do to try to influence, though, whether that decision gets made by the DA for your case to go to the prosecutor. And I think that one thing that we can do is let the prosecutor know a little bit about yourself before, your court date. So, like, when you get cited for shoplifting, you're going to get a court date on the ticket, and it's going to say when it is that you actually have to go to court, all right? What we want to do, in my opinion, is get information about who you are and, how this may impact you and any mitigation that you may do. For example, you may do a theft awareness course. You may do certain types of public service. You may do things to make yourself look better, to the prosecutor before they make a decision for your case to be filed or not to be filed, okay? So I think that, hey, yes, we should get this information over to the DA's office before they make a decision, all right? Now, you don't have to do that, okay? I call that the proactive approach, because I think that you could either be proactive and let the DA's office know, here's who I am, et cetera, as we discussed, or you could do the wait and see approach. And with the wait and see approach, you just don't do anything, and you see if the prosecutor comes, on their own to a decision that your case should not be charged in court and that you should be offered pre-filing diversion. All right? And then in that scenario, maybe you get lucky and your case isn't filed, or maybe you don't get so lucky and your case is filed and you'll need to go to court. All right? So those are the two ways you can handle it. You could do proactive, get information over before the charges are filed, or you could do wait and see and just wait and see if they're filed. Now, if the charges are filed and you have to go to court, well, gosh, you're probably going to need a lawyer, right? Unless financially you're unable to afford a lawyer, then you could get a court-appointed lawyer for you. I think that there is certain advantages of having a private lawyer. You may not have to go to court. The lawyer may do the appearances for you. Generally, what I try to do if you are a first-time offender and you are having to go to court is to get you what's called a diversion program. Now, we had talked about earlier pre-filing diversion, okay? Pre-filing diversions before charges get filed, but now if the charges do get filed against you, you may be eligible for, it's called Penal Code 1001.95. This is judicial diversion that's open to you if you're a misdemeanor offender, which here you would be, okay? And to get pre-filing diversion, it's completely in the judge's discretion. Even if the prosecutor doesn't want you to get it, the judge can do it over the prosecutor's objection. And the judge can create essentially a type of probation program, even though you're not on probation, a probationary program for you to follow certain rules and conditions. And if you follow those certain rules and conditions, then the judge can dismiss your case. And that's what diversion just means, basically. You are going to be diverted from the judicial system for a period of time. Your case isn't going to continue on the course of prosecution. The judge will have these rules for you to follow. You follow all the rules. If you're successful, then your case is dismissed. If you're not successful, then gosh, you're either going to end up going to trial and having to fight the charges, or you're going to take a plea deal. Those are the more likely outcomes. Okay, so you don't want to screw up your judicial diversion if you do get it. If you do get judicial diversion, again, you could end up with a clean record. The case is dismissed, and then later, you can file a petition to seal your arrest and your court record. Okay, so there's ways to keep this, off your record and so that the public doesn't have access to it. So those are, the things that you need to know in a nutshell. And if you want to talk more about it, feel free to let me know. Again, Nafiz Ahmed of Ahmed and Sukaram Attorneys at Law, and we're happy to talk. Thanks so much. Bye-bye.